My guest today is Professor Michael Dorf, who's Professor of Law at Cornell Law School. He has authored or co-authored well over 100 scholarly articles and essays for law reviews, books, and peer-reviewed science and social science journals. Welcome, Michael.
Hi, thanks so much. Glad to be here.
Yeah, so thanks for doing this. I want to start with, I guess this is a paper that you co-authored with your wife. If we did not eat them, they wouldn't exist. The non-identity problems, implications for animals, including humans. So you say here in the abstract, the non-identity problem raises the question whether an act that is necessary for a person's existence can also harm that person. For example, according to the non-identity logic, descendants of victims of historical injustices, such as slavery and the Holocaust, cannot explain or cannot complain about those injustices because the terrible events made their very existence possible. If a person has a life worth living, you say, then past wrongs, but for which she would not exist, seemingly cannot have harmed her. So I found this very, very interesting, Michael. In some sense, it goes to your intuition in a very logical way. But for most humans, I would say it's counterintuitive, right? So this is where the problem is, right? So how do you define the non-identity problem?
So the first thing I should say is that Sherry Kolb, who is the co-author of the article, and I didn't invent the problem. This is a longstanding problem in moral philosophy, and I think the key move in the paper is to connect it to something that she and I frequently encountered in some of our work in animal rights, which was a claim by people who eat animals that that's morally permissible because the particular animals that they eat would not have existed but for their exploitation. And so if they are treated minimally humanely and thus have lives worth living, there's no moral wrong. And so our insight was to connect that to this puzzle in the moral philosophy involving humans. And there are really there are families of responses to this puzzle, but it's generally recognized as a puzzle for precisely the reason you identify, which is if somebody is the descendants of people who were enslaved, it certainly feels like they were wronged by slavery. And yet, if they have a life worth living, how can we say that? Because in the absence of slavery, they wouldn't have existed. And so there are efforts to explain why they are nonetheless wronged. And I think some of those efforts actually succeed. I can talk about them in a moment.
Yeah.
And then the other direction that people sometimes go, and this is the best example of this in the literature, is by a philosopher named David Boonin, who's at the University of Colorado. What Boonin says is actually they're not wrong. They can't complain. I mean, maybe they can complain in the sense that any of us can complain about anything, but the intuition we have that the descendants of people who were enslaved or harmed by slavery is simply wrong. And that could be the case in moral philosophy. Part of the question, I think, depends on what one's sort of meta-ethical views are about the truth status of moral claims. I mean, there's a tradition that says moral claims don't even have any truth value. They're neither true nor false. They're just sort of they're like aesthetic judgments. They're completely subjective. That's not my view. But if that's your view, then there are no moral puzzles. But if it's not your view, then you need to sort of come up with it. And I think Boonin's answer is elegant, but it leaves one dissatisfied because of the existence of the puzzle in the first place. So let me say a word about what I think is the best effort to solve the puzzle in the case of historic injustices against humans, and then I'll say a word or two about the animal case. I think the best response, which I first encountered in a series of papers by Ori Herstein, who is a joint appointment at Tel Aviv University and King's College London, is that what makes historic injustices, the ones we think about injustices, is group harm. And one can be harmed as a member of a group, even if one does not experience any individuated harm, but simply being a member of the group, one shares in the injustice. And so in the case of slavery in the United States, people who are descendant of people who were enslaved have suffered from that. And in fact, you can even say that people whose ancestors were never enslaved, but who sort of are part of the group. So think about someone like, Barack Obama, whose ancestors were never enslaved, but grew up as a Black American in a culture that was affected by the historic injustice. Now, obviously, he's had a very successful life. He overcame it. Nonetheless, I think we could say that he was a victim of that historic injustice simply by virtue of being a member of the group that was harmed by it. Yeah. We say roughly the same thing for the animal species that are exploited by humans. But I think part of what we're trying to do in the article, I think the main thrust of the article, which, as I said, comes out of some work we've done in animal rights. I'm a vegan. That's where that, the moral force of that comes from, is to say that if the argument works in the animal case, if it really is true that it's okay to eat an animal that was raised humanely because, the benefits the animal got out of coming into existence outweigh the harm from its slaughter and so forth, then that justifies all sorts of horrible things with respect to humans as well, right? That is, there might be reasons to distinguish between humans and other animals for all sorts of various purposes, but the logic of the argument that says, if I created you, or if some act created you, you can't complain about it if you have a life worth living, that's identical regardless of whether you're a pig or a cow or the descendant of somebody who was enslaved or subject to the Holocaust or whatever. So that's the core of the argument.
Yeah. So there is sort of two things here. One is sort of existing and not existing. Is there a difference? And then there's sort of a utilitarian. So I used to think, Michael, I am a utilitarian. I'm not sure anymore, actually. So, the question of sort of the area under the curve, do you want to sort of maximize that area under the curve question? But the larger question is that the right optimization problem we are trying to solve? But more importantly, I mean, this is more philosophic in the sense that what's the difference being not existing and existing in some form, whether it is a life worth living or not necessarily so? Is there a huge difference there? So yeah, how do you think about this?
Yeah, so let me say a word about utilitarianism, and then I'll address this question about comparing existing versus non-existing. So I think if one is a thoroughgoing utilitarian, then I do think that dissolves the non-identity problem and various other sorts of dilemmas, because then you just kind of add up the utility versus the disutility, and if the sum is positive, you're benefited, and so you can't complain. So I don't think there really is a puzzle here for utilitarians. There are all sorts of familiar reasons why one might want to resist being a utilitarian, having to do with our intuitions about moral rights and so forth, and respecting the boundaries between individuals, etc. So the article is, and I think the whole literature of the non-identity problem begins with the premise that one is not a utilitarian. Okay. So having said that, part of the discussion in our paper concerns whether it is possible to make comparisons between being in, on the one hand, either a good state or a bad state as an existing being versus not existing at all.
Yeah.
And the one view is, well, no, if you don't exist, you're in a state of zero well-being. You don't have any positive or negative well-being. And so an animal or human who has a negative utility to their lives, I'm using the term utility, but not in utilitarian sense, but someone who has a life not worth living is worse off than non-existing, and someone who has a life worth living is better off. But there is a view, which I think we are attracted to, that says that, no, that's not right. You simply can't compare existing in any kind of state to non-existing, because non-existing is it's a kind of it's a totally different universe. The world doesn't exist for you, so how can you have any state? And so one of the moves we make is to say that but bringing a being into existence can nonetheless be harmful to that being, in that once you bring that being into existence, you've now endowed that being with certain experiences, conditions, etc. There's a very interesting article we discuss in our article by Shauna Schifrin, who is a moral philosopher and a law professor at UCLA, who takes the view that it is wrongful to have children. Why? Even if those children will have lives worth living, that is to say, their net utility from their lives is positive, because you, in bringing them into existence, you know they will suffer. And so you are harming them. Now, it's true, you're also benefiting them, but in ordinary morality, we don't think that if you confer a benefit on somebody, that entitles you to also harm that somebody, even if the benefit, in some sense, overcompensates for the harm, at least if it's done non-consensually, right? You couldn't go around town, punching people in the face and then handing them $1 million, right? You would still have committed the tort, even though if they were to sue you for the tort suit, they would probably get less than $1 million as an award. And so Professor Schifrin's idea is that therefore bring people into existence harms them. Now, we don't agree with that. We don't think that existence is necessarily harmful, but we do agree with this idea that in some sense, once you bring the being into existence, that's when the clock starts. So you have to take the blame for the harm that befalls them.
Yeah, so this is probably the utilitarian in me, Michael. So suppose I integrate utility over a model, human or non-human animal, and I find that the net outcome of a life is always negative. I'm just making this up. Let's say it's always negative in aggregate. Then one could argue, it's a crime to bring an animal or a human to the world. I don't know what the answer is. I'm just putting this out there for you to react to.
Yeah, so I think that is a non-trivial argument, and I don't think it depends on assuming one's a utilitarian. I mean, there are a lot of, I'm 60, my children are in their 20s. I don't know whether they will have children, neither of them has any yet, but I know that a lot of people in their generation are highly reluctant to have children because, given the environmental crisis and all sorts of other pressures, there are reasons to think that life for people born now or in the next decade will be quite bad. And so it's a potential harm to those potential children themselves, and of course, given the additional demands on the carrying capacity of the Earth, on everybody else. So I think it is perfectly logical to worry that bringing somebody into existence is a wrongful act, simply in virtue of what they and others who are going to be affected by their consumption will experience.
or so I want to return to the identity problem again. So the confusion here, if I understand this correctly, Michael, I have no background in this. The confusion here is that people argue that not being in existence is somehow superior to being in existence. Is that the crux of the argument?
So I don't think that's the crux of the non-identity problem. The crux of the non-identity problem is the paradoxical inability of people to complain about misfortunes occasioned by the very act that brought them into existence if they have a life worth living. Um,
Yeah.
but one of the efforts to solve the puzzle involves comparing the utility of an existing being to that of a non-existing being, and that's a genuine sort of conceptual difficulty because, right, again, the utility of a non-existent being could be conceptualized as zero, but that's just a very strange way to think about it, given that it is a non-existent being. As you might imagine, there are overlaps between this branch of moral philosophy and debates about abortion, for example, right? That is, Sherry and I wrote a book before this article called about abortion and animal rights. The and the origin of that book was that we found that people who either were sympathetic or unsympathetic to our position with respect to animal rights wanted to know how is it one could be in favor of rights for non-human animals, but also support abortion rights, given that human fetuses have interests and so forth. And our answer on the sort of moral front, not the legal side, but on the moral side is, well, we think that abortion does raise serious moral issues once a fetus acquires sentience, that is, the ability to have subjective experiences, which isn't true of fetuses at the stage at which the vast majority of abortions occur, but is true of about 10% of the abortions. And so those do present serious moral issues. But then we face the question of, well, what about those pre-sentient fetuses, right? That haven't yet come into existence, but are sort of their potential lives. And you might think that they, and even people who've never existed, there's preconception, right? The possibility, right? Well, they have potential interests. And so thinking about that is in some way closely connected to this question of, well, what is the interest of someone who doesn't exist but could exist? And is that even conceptually sensible?
Yeah, so you talk about the endowment effect in the paper, and there is an asymmetry there as well. That is quite interesting. So suicide, euthanasia, you talk about these, is quite different from the decision not to bring a human to this world, right? So
Yes.
once a human is in the context, then taking that human away. And I was wondering, Michael, I don't know if you discuss this or think about this. Taking the human away is not just for the negative utility for the human. It could be zero. I don't know for the human, depending on the circumstances. But it also affects the society, right?
Sure.
So there is an overall aggregate negative utility for the society by that action, whether suicide or euthanasia or whatever. And so the endowment effect is quite high, right,
Yeah.
in this problem. Yeah.
Right. So just for the benefit of listeners who aren't familiar with the endowment effect, so because we use it in a slightly different sense from its canonical use. So the endowment effect, as classically defined, is a psychological phenomenon, right, whereby people value things that they have more highly than things that they don't already have. So there are all these classic psychology experiments where if you give somebody a pen that's of no great value, that they're less likely to part with it than they would be to acquire it in various. So that's a psychological phenomenon. I think most psychologists regard the endowment effect as a kind of irrationality.
Yeah.
Our view is that it's not entirely irrational, and it in fact is embedded in a whole lot of our moral theory and certainly in our law. So that the whole institution of private property really rests on the endowment effect, what we call a moralized endowment effect. So that's what the endowment effect is doing in our argument, because it's not just a psychological mistake. It's this idea that there is good reason sometimes to say that having something and losing it is a greater delta than never getting it in the first place. And I think you're absolutely right about the social aspect, right? That is to say, if we want to think about it in aggregate terms, of course, losing a loved one is a much greater harm than not coming into contact with what might have been a potential loved one.
Yeah, so there's a planning horizon. So I'm just making this up, Michael. I don't know much about this. So suppose I have X, and I can now plan around X. If I don't have X, I won't be able to plan. And so in the former case, I have more cost. I planned around X, and if I lose X, I lose the whole plan. Whereas if I don't have it, then I'm not planning around it. Is that the issue?
So I think that is a version of the endowment effect that escapes the psychological critique, right? And in the law, that corresponds to protection for what are sometimes called reliance interests, right? Which is that a big reason we have law in the first place, and certainly the institutions of private property, are to facilitate planning by relying on predictability, right? You can predict that if I own this piece of land today, I will own it 2 years down the road, unless I voluntarily choose to sell it. And therefore, I can build whatever it is I want to build on this piece of land, or whatever the project is. I think that's clearly right. I think what the psychologists would say is that's not an example of the endowment effect. That's just a sort of useful social construction. The endowment effect would be if you overvalued it, not because of any ability to plan. So forth.
Yeah. Yeah, excellent. So I want to go into another paper. So in this non-identity problem, do you want to conclude on, so what are your major findings in this paper?
So I think that we have two main takeaways. First is I think we want to say that the endowment effect does undercut the claim that it's not a harm to bring a being into existence only for the purpose of, harming that being. Number one. Number two, we want to associate the animal case with the human case with respect to group injustice. Number three, we want to say that we are nonetheless left a little bit uneasy with all of the solutions to the non-identity problem. Yeah. But that's a problem for no more or less for the human case than for the non-human animal case. And so the sort of meta takeaway is that thinking about moral problems in the context of interhuman relations alongside questions about what our moral obligations are to non-human animals is actually fruitful in both directions. And so in that sense, it's kind of saying like, well, you don't have to agree with us, but if you find this interesting, maybe there should be more work like that.
Yeah, I found very interesting, Michael. So it gives you a higher context, to sort of compare things, and it might give you insights if you don't do otherwise. So I want to go into another paper, which also I found very interesting, how to choose the least unconstitutional option, lessons for the president and others, you say, from the debt ceiling standoff. I sort of remember this, Michael. So from 2011, so the federal statute known as the debt ceiling limits total borrowing by the United States. Congress has repeatedly raised the ceiling to authorize necessary borrowing, but a political standoff in 2011 nearly made it impossible to borrow funds to meet obligations that Congress had affirmed earlier that very year. So, so you're talking about here that as a president, if you have three options and you sort of look at those options, and you're arguing here that take the least unconstitutional option, which seems like an optimization problem in some way. So how do you think about this?
Yeah. So first, this is a recurring problem over the last nearly decade and a half now. We wrote the original paper in response to a crisis in 2011, but listeners will recall that this recurred about a year ago when it looked like the House of Representatives was again not going to raise the debt ceiling, and then there was this last-minute deal between then Speaker Kevin McCarthy and President Biden. And depending on the configuration of the political forces, this is potentially going to recur, possibly as soon as January 2025, but if not then, at some point down the road. And so this, I should be clear, this is the initial paper, and the 2 to 3 dozen follow-ups that I've written were all co-authored with Neil Buchanan, who is an economist and also a law professor. He's emeritus now at the University of Florida. He's based in Toronto currently. And so he comes at it from the fiscal policy, macroeconomic side. I come at it from the constitutional lawyer side. And the driving force for this paper was a disagreement with what had become the conventional wisdom. Since I think we've pushed that conventional wisdom a little bit away, but there's still a lot of people who believe in the conventional wisdom, which is that in the event that we get to a point where Congress has passed laws that collectively require spending more money than the sum total of borrowing and taxing authorizes, the conventional wisdom says, well, just don't spend all the money. Spend as much money as you have in the till, and don't spend any more of that. And our best analysis as constitutional lawyers, or mine as a constitutional lawyer, Neil brought the economics expertise, was that, well, no, that doesn't work either, because the executive branch does not have the authority to cut spending. The president can veto a bill he doesn't like if it spends too much money, but once Congress has authorized through a bill that the president has signed spending a certain amount of money, you have to spend that much money. And we know this because President Nixon in the 1970s tried to do exactly this thing, not to spend a bunch of money that Congress had authorized him to spend, and he lost. There's a series of cases that say that. Yeah. And so our analysis was that in the event that this happens, it would be like Congress simultaneously passing laws that said do X, but also don't do X. Now it's 3 laws rather than 2, and it's all in the same law. We have tools for how we think about how to reconcile seemingly conflicting laws. We try to find a way to comply with all of them. If there's an irreconcilable conflict, you say the last in time prevails over earlier in time ones. But what if they are all sort of come about more or less simultaneously? And it turns out that given the timing of the debt ceiling things, you never know which one is going to be the most recent in time. So the question is, what do you do if you have contradictory commands? And our answer, I think, is very, very simple and makes a lot of sense to people who aren't lawyers, which is if you have contradictory commands, you can't comply with all of them. So you comply with them as much as possible in the way that does the least damage. So when it's explained like that, I think it's hard to even disagree with us. Part of the reason why I think we got some pushback in the first place is that Americans aren't used to the idea that you could have only unconstitutional options. Their idea is, well, the Constitution is the basic law. It's always going to have an answer. And that's not my view. I don't think the Constitution was written by God. There are all sorts of reasons why it could lead to contradictory results. It could contain contradictions. And so you have to sort of do your best. And so that's what we're doing there. And then I would say about 80% of what we've done since that initial article falls into one of two categories. Either just trying to explain that over and over again, to say that anything the president does, cutting spending, raising taxes, or borrowing in excess of the debt ceiling would be unconstitutional, a usurpation of the authority of Congress, right? And saying that therefore you're stuck no matter what you do. There's no solution. You have to minimize the harm. So it's partly that, and then partly shooting down crazy ideas. So one you may have heard of in one of these iterations was this notion that the president could instruct the Treasury, the mint, to create 2 platinum coins, each worth $1 trillion, and deposit these. And there are both common sense and technical reasons why this doesn't work. Another thing we've heard is people say, well, the president could, quote, invoke the 14th Amendment. There's a provision of the 14th Amendment that says that the validity of the public debt of the United States shall not be questioned. And so some people argue that that means that the debt ceiling statute is unconstitutional because it amounts to a questioning of the public debt. We're sympathetic to that argument, but that argument is then suggested that therefore the president could just invoke it, sort of like Harry Potter invoking his Patronus, and all of a sudden it's like this magic solution. And we still think he'd be acting unconstitutionally under these other authorities. Go ahead.
Yeah, good. So no, I was just going to say, so in the conclusion here, you say that we emphasize 3 principles derived from a famous speech by President Lincoln. 1, minimize the unconstitutional assumption of power. 2, minimize the subconstitutional harm. And 3, preserve to the extent possible the ability of other actors to undo or remedy constitutional violations. And so it's almost like a framework, right? So we have had this framework for a while. I think if I understand this correctly, Michael, you're saying take that framework and apply it. And given that you have only 3 options, you apply that framework and see what comes out of those 3, and pick that.
Yeah, I should say we didn't invent any of those criteria, but we did put them together as a framework. And I should say a word as to why we think that borrowing in excess of the debt ceiling is the least unconstitutional option. And it's mainly because it involves the smallest, actually no, usurpation by the president of legislative authority, right? That is to say, if the president's going to start cutting spending, there's all sorts of discretion about which spending to cut, when, how much, etc. By contrast, if you violate the debt ceiling, you know exactly how much to violate it by. You violate it by borrowing exactly as much money as you need to make up the shortfall in the Treasury. So there's no discretion involved. So in that sense, it's a very familiar principle, right? We don't want government officials to have unbounded discretion. And so the problem with the president should cut spending idea is it gives the president unbounded discretion. As far as the minimizing the subconstitutional harm goes, right, there we're less confident that our approach does that, although we still think it probably does. But the difficulty with any of these approaches, including ours, is that it's very dependent on how the markets react, right? That is, if the president starts borrowing money without Congress's authorization, right, that would almost certainly lead to a downgrade in the value of U.S. Treasury notes, debt, so forth. Some people have said, therefore, that you can't do it. I think that's a mistake because the these what we call presidential bonds would not have to be sold to the general public. They could be sold to the Federal Reserve, which would buy them, and then it has to buy them under the relevant federal law under what are called open market transactions. But it turns out that you could have it in a way that it's really only going to the Fed. So that gets a little bit into the weeds, but you're right that the big takeaway is indeed this framework, which we associate it with Lincoln, because the Lincoln example is when he unilaterally suspended habeas corpus because he needed to win the Civil War and Congress wasn't in session. And when he did it, he wrote a message to Congress. He said, when you come back here, if you don't like what I did, don't ratify it, and we'll undo it. And so that's sort of our position as well, which is Congress can fix this problem at any time.
Yeah, so very quickly, Michael. So the way that I would think about this from an economics perspective, if I'm given three options, I'll value them economically. And my gut feel is that whatever gives me more flexibility, that I can sort of reverse it in the future, let's say, may have higher value. So for instance, as you say here, suppose I go out and say, give it the three options. I'm going to borrow more money. I'm going to issue more bonds. I always hold the option to reverse it at a future time. For instance, if the economy comes roaring back and, I can pay off some of those bonds, I have that option. In other cases, it's sort of done deal, right?
Well,
the two options.
So I think there's an ambiguity in what you mean by I here, right? So if you're the president, right, we actually don't want you to have a lot of flexibility, right? Part of the virtue of the treating the debt ceiling as, violating the debt ceiling as the least unconstitutional option is precisely that the president doesn't have flexibility, but the flexibility is retained by Congress, which has the constitutional power to borrow, to spend, and to tax. I think the thought is that whether you're going to pay off the bonds and at what rate and so forth, I mean, you're going to always want to pay off the bonds. The question is how much additional borrowing you need to do, if any, to take care of that. That's a sort of a question for the system as a whole. And so we want to minimize the flexibility the president has in the sense of unbounded discretion that probably belongs with the legislative branch, while at the same time maximizing the reversibility, not by the president, but by Congress at a later point. I do think that some of the other options have that feature. That is, the spending, a spending cut could be reversed later in the sense that you pay the people, except that, depending on whose spending is cut, they might have suffered serious harm that can't be compensated in the meantime, right? So, some of the people who might be entitled to money are doctors in hospitals for providing medical services that they might not get and therefore might not provide the medical service. And therefore, someone could suffer an irreversible health outcome as a consequence.
Yeah, so I want to go into something very topical, Michael. So regulating civil disobedience on campus. You say here a person engaged in civil disobedience typically violates the law that is itself regarded as unjust. You say here Mahatma Gandhi was jailed as a result of the salt march, which violated the law that restricted local harvesting of salt to benefit Britain's global commercial interests at the expense of India. He violated the prohibition on harvesting sea salt, which was the very law he was protesting. So in the larger context here, if I understand this correctly, and going back to the campus protests, I mean, we all have seen it. We all know what's going on in the Gaza and the Israel arena. There have been a lot of protests, and from my perspective, they have been very non-uniform. I mean, all the schools saw different things. I went to Northwestern. It seems like Northwestern did it differently from Columbia, for instance. And so So what's sort of your thesis here in terms of how we should deal with it?
Yeah, so let me contextualize this a little bit, right? So you're right that the immediate occasion for this is the student protests over Israel's war in Gaza, and um, at so some universities like Northwestern chose to negotiate with the student protesters. Um, Others like Columbia, like Texas, University of Texas, although it wasn't the university, it was more the state government, right, chose to send in the police. Um, there are a bunch of places that are sort of in the middle. So Cornell, where I teach, they never called in the police, but there were at least some suspensions of some of the students. And so what I'm uh, trying to get at here is to see whether there's some middle ground between, on the one hand, saying that if students break any rules, like they have an unauthorized protest, or they set up an encampment without a permit, or when it's supposed that space is supposed to be used for something else, no matter what they do, you throw the book at them. Versus on the other side saying, well, they can do whatever they want because they've got, it seems like a just cause because the war in Gaza is exacting terrible toll. And the needle I'm trying to thread is to say that you only really want to crack down on campus protests if they are posing very, very serious problems, like committing or threatening violence,
Yeah.
very serious property damage, or, as in some, but certainly not all or even most, involve targeting of other students through anti-Semitic or other acts that violate other campus norms. But if all they're doing is violating your rules about who has access to what space when, and maybe being a little bit noisier than you'd like, and maybe they're damaging the grass, but no differently from the way that a reunion does, is there a way to recognize that what they're involved in is something like civil disobedience? Now, the language that you quoted is me posing for myself the question, well, what is this really civil disobedience?
Yeah.
Because we normally associate civil disobedience with the violation of an unjust law or rule, right? So that the law that Gandhi was violating was itself an exercise in British imperialism, and he's violating that specific law. Likewise, there are other examples, but I ended up talking myself out of that objection because I thought about a letter from a Birmingham jail by Martin Luther King, right? So he's in a Birmingham jail because he violated a rule about unauthorized protests. Now,
Yes.
arguably that rule was itself unjust, but the core injustice was not Alabama's rules about who gets to protest where and when. The core injustice was Jim Crow segregation. And he's not violating that. That is to say, King ends up in jail for violating a rule about speech, and that's different from Rosa Parks violating the rule about where you get to sit on the bus.
Yeah.
Nonetheless, I think I want to say that King falls within the broad spectrum of what counts as civil disobedience, and that it's a kind of that notion of civil disobedience encompasses just about all nonviolent, non-threatening rule or law violation to make a point about injustice. And therefore, I think there has to be some greater accommodation than simply, well, you're breaking the rules, therefore we're going to suspend you, or even worse, call in the cops. Doesn't mean there can't be any consequences. Right?
Yeah.
You might have some sort of, community service because you ended up damaging the grass, so you got to spend a few hours reseeding the grass or something like that. But it's an attempt to say that there's this intermediate category of rule breaking that you don't want to encourage, but you also it's not appropriate for an institution that is trying to foster, freedom of speech and similar values, to say that you crack down super hard on them.
Yeah, I mean, it's a fine line, isn't it? I mean, another paper you have is on the same topic, federal anti-discrimination law does not require campus crackdowns. You say here more broadly, a sensible starting point for reconciling the competing values of free speech and protection from harassment on campus would be to recognize that on-campus means different things in different places. So yeah, a campus is a complex system, and I mean, in some ways, and I'm just throwing this out there, Michael, I don't know much about this. In some ways, it's a place to protest in the sense that, this is an assembly of intellectuals, assembly of people who think independently, and they are the ones to protest what general public cannot. So there has to be a safe space. I'm just throwing this out for you to react to on the campus for them to do that, right? In some ways.
Yeah. So I think there's a kind of double-edged quality to the university or college campus setting. On the one hand, as you say, part of the point, the raison d'etre of universities is free inquiry, freedom of expression. We have academic freedom. We want people to express their views. And therefore, if there's any place where people should be able to have robust statements, even if other people are offended, it ought to be on a college campus. And you've actually heard this position voiced prior to the most recent controversies. This position was voiced most articulately, I think, by people on the right who were complaining about no platforming or so-called snowflakes or whatever. They said you should have anybody who wants to come make their speech. If you're offended, you're offended. Don't go, whatever, right? And I'm sympathetic to that view that says that a campus should be a place of free inquiry, free speech, and if some people are offended, so what? On the other hand, there are at least two factors that cut in the other direction. One is that for many students, at least at non-commuter schools, there are parts of the campus that are their home, right? So, so a dormitory, in this view, is a very different kind of space from the quadrangle where people might be out, and it's like a public park. Okay, that's one way in which it cuts the other way. We don't think that it's generally permissible to hold a protest in somebody else's home. So there's got to be something there. The second thing, and I'm not sure where I come down on this, is that we like to think that debate and disagreement in a college or university setting follows certain rules of decorum, right? That is to say, it's true that generally free speech means you get to say things in whatever manner you want, you get to shout your slogans, etc. But I think we'd like to think that if people have come to a college or university, they want to hear arguments. They don't want to just hear slogans. And so where I think that leads me is to say that I understand that people ought to have a right to protest and to do so in ways that are crude and use slogans, etc. But I would prefer if they could have a reasoned, rational discussion in which people who hold different views air those views without fear that they're going to be shouted down or called names or doxxed or anything like that. And for that reason, it's not clear to me that campus protests are the sort of, I think they should be protected, but I'm a little uneasy about thinking of the university as just like the Twitter or some other place where people say whatever, pops into their head without regard to whether it's an argument, whether it's reasoned, and so forth.
Yeah, I mean, your idea about this spaces are different. I think that there's something to it. I haven't really thought through this. So going back to Northwestern to Columbia sort of contrast, Northwestern has a lot of lakefront property,
Mm-hmm.
and they could go there and protest, and it's not going to do anything to the dormitories or anything. Whereas in Columbia, I mean, it's right in New York City. I don't know exactly how it's configured. It could create more issues.
Yeah.
Let's call it.
So I know Columbia. I taught at Columbia from 1995 to 2008, so I know it pretty well. And I would distinguish between the encampment, which was on the main quad, which is bounded by Broadway and Amsterdam on one side and 112th Street and about 118th on the other. Big. There are buildings all around it. Some dormitories, some academic buildings. And it's like a big park, except that a lot of it is concrete, but there are grassy spaces. So in that sense, it's kind of like an urban park. I would distinguish between the protests there versus the takeover of Hamilton Hall. Now, Hamilton Hall is a building, of course, and that's different. What Columbia had said was that they wanted to limit the protests to specific areas. Part of it was about ingress and egress with respect to particular buildings. And, I do think it's worth distinguishing between being in a place where people find what you're saying annoying or even offensive on the one hand, versus actually blocking access to a building. And, again, these are not new problems. We've got a lot of legal cases involving that sort of issue, many of which arose out of abortion protests, right? So you had anti-abortion protesters who would, they still do this, right? Stand outside abortion clinics, holding up signs and saying things that were undoubtedly very disturbing to the people going in there. And the basic rule is you can do that, but you can't block access. You got to have a little bit of a buffer zone. Right. It seems to me that is a reasonable approach with respect to campus protests, and how big the buffer zone is supposed to be will depend on whether you're in Evanston and you've got all this extra room, or whether you're on Morningside Heights.
Yeah, it is sort of a optimization problem. So you feed in the geography of a campus to an artificial intelligence program, and it's going to have green spaces and red spaces that come out to say, this is where you let the protesters, this is where you don't let the protesters. I don't think we are too far away from that.
Yeah, well, except, I mean, part of the problem, I think, with doing that is that, as I sort of tried to say in the piece about civil disobedience, part of the force of the protest is that it is meant to be transgressive, right? That is, so whatever you can say, well, if you can protest here but not here, well, then this prohibited space becomes more attractive to the protesters.
Right.
And then the problem is, if you build that into your sort of system of punishments, like, well, now have you authorized it? And so now they're going to go to this third spot. So there's a kind of recursive nature to this.
Yeah, I see that. Yeah. Excellent, Michael. Thanks so much for spending time with me.
Oh, it's my pleasure. We could have talked about any number of other things as well, but I'm glad these were 3 topics that
absolutely. Yeah, I should come back and we can have another conversation.
Great. All right. Thank you so much.
Bye.